COVID-19 discussion. The idea is to explore different scenarios which may arise in the workplace due to new COVID-19 related incidents and to stimulate discussions on these. I'm Farinana and I'm an associate at Maserumule Corporate Employment Law. I'm joined by my colleague Ulrich Stander, who is the managing partner at Maserumule. Today's topic is what if employees refuse to continue working due to exposure or risk of exposure to a suspected or confirmed COVID-19 case. Today, Ulrich will be kicking off this discussion. For social distancing purposes, I'm going to step away from the screen, but I will still be involved in the discussion. Thank you, Ulrich.
Good afternoon, everyone. Thank you, Farron, for the introduction. Many employers, companies have been confronted since April with scenarios where employees are too scared to work, to continue working, or in fact to return to work as we move during the various levels of lockdown and return to work. We haven't had much guidance on this issue from the Department of Labour, but quite recently, in fact on the 4th of June, a formal directive was published called the Consolidated COVID-19 Directive on Workplace Safety. This directive addresses a number of issues in respect of workplace safety, and among others, it specifically addressed the issue around refusing to work due to COVID exposure. Paragraph 48 to 56 of this directive deals with this fairly complex issue. Now, paragraph 48 states that employees may refuse to work in circumstances where there's reasonable justification to do so as a result of imminent and serious exposure to COVID-19. It also adds that if an employee is of the view that there is an imminent risk of exposure, that he needs to inform the company as soon as reasonably practicable. And then it states later that no employer may take any disciplinary action against employees for exercising their rights in terms of paragraph 48, and that is the refusal to work under those circumstances. So I think many employers would be quite concerned about this, but I think we need to delve a bit deeper into paragraph 48 and ask ourselves the question, what does it actually mean? Does it mean that any employee can now refuse to continue working or return to work merely based on a subjective view that there's a risk of exposure and that then would be justified? And I think the good news is that is not what paragraph 48 implies. In fact, paragraph 48 sets a number of requirements for this refusal to be valid. And if we look at it and we analyze the content, we see that there needs to be a risk of exposure that is imminent. There needs to be a reasonable justification to refuse tendering your services. And a reasonable justification implies that it's an objective test. So it's not a subjective view, but it has to have a set of facts on which that opinion is based on, objectively verifiable. As I've indicated, there needs to be an imminent risk, which in itself implies that there needs to be a factual basis for that requirement, and also the employee needs to inform the employer of his or her concern, meaning that an employee cannot stay away from the work for a number of days, return, and then justify that absence based on a reasonable apprehension of risk. Should that happen, clearly he or she did not comply with the requirements of this specific paragraph. So in very simple terms, there needs to be an objective justification for a refusal to work. And if these requirements are not met, then there is no protection under paragraph 48, and that refusal to work may in fact be unprotected. It is not a simple issue, because we're certainly going to have cases where employees would refuse, and one cannot have a one approach fits all as a solution here. You would need to take it from a case-to-case basis to determine if whether such a refusal is in fact objectively justifiable. So it is a complex matter, and employees will have to take a view on how they're going to address it going forward.
Okay, Ulrich, we have some questions I'd like to ask. So, Ulrich, what happens if an employee refuses to work due to the COVID-19 concerns? I think you've covered that quite substantially, but so what if an employee does not have a reasonable justification but refuses to come to work?
Yeah, so there are two scenarios. In one case is he or she would have a reasonable justification, in which case it would be valid and reasonable not to tender services, expecting that the issues are resolved at the workplace. And a further interesting question, obviously, is what would be the obligation on the employer to pay that employee? If there was a reasonable justification not to tender your services, and that's being validated, then the employee was prepared to tender his services, but these circumstances prevented him to do so, and so that in our view the payment obligation will continue. But if the refusal is not justified after a proper investigation has been done, the employee does not have the protection of paragraph 48, and therefore may in fact be exposed to some kind of disciplinary action for a refusal to work, non-attendance without justification without justification. I think the important point is how does the employer approach it? And I think one needs to approach it from a case-to-case basis. There may be cases where employees are ill-informed, anxious, worried, in difficult circumstances, and it may be useful to consider a sort of cool-off period of a day or so, this or that way, prior to merely taking a fairly hard stance, or be it at the last, taking a hard stance and implementing disciplinary measures would be justifiable. I think it's also important that if that employee, in the process of convincing the employee to continue tendering his services, is that the employer needs to continue engaging, sharing information, sharing the various measures they take in order to comply with safety protocols, directives, control measures, administrative measures, etc. So trying to convince that the employer has in fact done all what was reasonably possible in the circumstances to ensure workplace safety. I think no public place in general is 100% safe in the COVID context, but the obligation on the employers would be to take all reasonable steps, and following the guidelines in the directives, of which there was an abundance of them published since April. So I think a pragmatic approach is important on the one hand. On the other hand, technically, there's an option to discipline if there's non-compliance to the requirements of paragraph 48.
Okay. And sorry, just how should an employer resolve any dispute? So an employee comes, they've already started working, and they now feel that there may be a suspected case of COVID-19, and how does the employee then deal with those disputes, or the employee's refusal, if there is perhaps a valid justification, a reasonable justification for the employee not wanting to attend at the workplace?
So Farhan, maybe I should also take a step back. You've again referred to the valid justification or reasonable justification for this view that there's an imminent and serious risk. I think the question one needs to ask is, these incidents will happen. Employees are human beings. They've got emotions. They've got concerns. From a COVID context, it's a fairly threatening environment. People return to work, which is again a new experience. So there will be cases where people have concerns, in many cases justifiably so, and others not. But there also will be cases where people refuse to, or employees, workers refuse to tender their services. So if a company anticipates that, the question is, how do you prevent that? Or how do you reduce those incidents? Because you don't want to deal with these on a day-to-day basis. And I think in order to circumvent, or in order to, in a way, nullify that reasonable justification, companies will have to make sure that not only that they implement all the measures prescribed, safety measures, as I've referred to previously, but all of that is not worth a lot if, at least from a relationship point of view, if these are not communicated and shared, and if there's not a regular engagement. So it's quite interesting if one looks at the specific directive, then it states specifically that the content of this directive, which by the way is roughly a 19-page document, that content needs to be shared with employees, and it needs to be discussed. So if a company fails to do that, then you can expect more employees acting irrationally and following the route of not tendering their services. So in order to indicate or show that an employee doesn't have a reasonable justification for his apprehension, there's an onus on the company to engage, and there's an onus to engage proactively, and that engagement means education, orientation, and sharing of all relevant information. If that is done abundantly, then little, if at all, employees will have a justification or a reasonable justification for their concern. Obviously, assuming that the company does apply all the measures as they are expected to apply. So maybe then, how do you counter these possible incidents of complaints or refusal to work? Well, you engage and you do all that is reasonably possible, apart from implementing safety measures, to convince employees that everything what could be done is in fact in place. So if it is then found that after thorough investigation and engagement that the employee's refusal is not justified, then as I stated before, the employer potentially can discipline or allow for a cooling off period and use that time to convince the employee, or the group of employees for that matter, to convince them differently. If that doesn't happen, and the employee in fact decides ultimately to take disciplinary action based on absence from work without a valid reason, then in terms of paragraph 56, if I remember correctly, of this directive, the employee may refer the matter to the CCMA to be adjudicated on, and so then whether disciplinary action was taken or not, whether there was no pay, no work, no pay, those actions will be tested, and the CCMA will have to pronounce on the reasonableness of the action of the employer in the circumstances. And again, in assessing any such matter, what the employer would want is to get a finding where it is confirmed that they have taken reasonable steps to provide a safe workplace. And in order to get there, as I stated before, they need to convince the employee that they have in fact implemented all possible measures. If they fail to do it, we will have regular and frequent groups of employees or even individual employees alleging that, or in fact not tendering their services due to their apprehension of possible COVID risk to exposure. I hope I've answered your question there.
Yes. Thanks so much, Ulrich.
Thank you.
Okay. I hope that provides you with some clarification on our topic today. For any further advice on this topic, please feel free to contact us. You can pop us an email or give us a call. Our details are all on our Facebook page. And we will see you at our next session. Thanks.